far as a notice sent under postal certificate is concerned, in two parties versus others, a bench of three judges of this court on the facts of that case refused to accept that the notice sent under a postal certificate by a detainee under the Conservation of Foreign Exchange and Smuggling Activities Act 1974 to the Assistant Collector of Customs retracting his original statement had been duly served on the concerned office stop. This was because the respondent rebutted the submission by producing their file to show that such a letter had not been received in their office in the normal course of business stop. However, the proposition laid down in that case is relevant for our purpose stop. The certificate of posting might lead to a presumption that a letter addressed to the Assistant Collector of Customs was posted on August 14, 1980 and in due course reached the addressee. Stop. But that is only a permissible and not an inevitable presumption. Stop. Neither Section 16 nor Section 114 of the Evidence Act compels the court to draw a presumption. Stop. The presumption may or may not be drawn. Stop. On the facts and circumstances of a case, the court may refuse to draw the presumption. Stop. On the other hand, the presumption may be drawn initially, but on a consideration of the evidence, the court may hold the presumption rebutted and may arrive at the conclusion that no letter was received by the addressee or that no letter was ever dispatched as claimed. Stop. After all, there have been cases in the past, though rare, where postal certificates and even postal seals have been manufactured. Stop. In the circumstances of the present case, circumstances to which we have already referred, we are satisfied that no such letter of retraction was posted as claimed by the detainee. Stop. The proposition laid down in this judgment has been followed into subsequent cases coming before this court in the context of Section 53 of the Companies Act 1956, providing for presumption of service of notice of the board meeting sent by post. Stop. In case of two parties versus others, a bench of two judges of this court referred to the proposition in bracket supra in para 117 of its judgment and held in the facts of that case that the notice by postal certificate could not be presumed to have been effected since the relations between the parties were embittered and the certificate of posting was suspect. Stop.